Legislative classification. A right conferred on persons that they shall not be denied equal protection of the laws does not mean the protection of the same laws for all. It is here that the doctrine of classification steps in and gives content and significance to the guarantee of equal protection of the laws. To separate persons similarly situated from those who are not, legislative classification or distinction is made carefully between the persons who are and who are not similarly situated. The Supreme Court, in a number of cases, has upheld the view that Article 14 does not rule out classification for the purposes of legislation. Article 14 does not forbid classification or differentiation which rests upon reasonable grounds of distinction. The Supreme Court in State of Bihar versus Bihar State +2 Lectures Association held that now it is well settled and cannot be disputed that Article 14 of the Constitution guarantees equality before the law and confers equal protection of the laws. It prohibits the state from denying persons or class of persons equal treatment, provided they are equals and are similarly situated. It, however, does not forbid classification. In other words, what Article 14 prohibits is discrimination and not classification, if otherwise such classification is legal, valid, and reasonable. Test of valid classification. Since a distinction is to be made for the purposes of enacting a legislation, it must pass the classical test enunciated by the Supreme Court in State of West Bengal versus Anwar Ali Sarkar. Permissible classification must satisfy two conditions, namely, it must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group, and the differentia must have a rational nexus with the object sought to be achieved by the statute in question. After considering leading cases on equal protection clause enshrined in Article 14 of the Constitution, the 5-judge bench of the Supreme Court in Confederation of Ex-Servicemen Associations versus Union of India stated, in our judgment, therefore, it is clear that every classification to be legal, valid, and permissible must fulfill the twin test, namely, the classification must be founded on an intelligible differentia which must distinguish persons or things that are grouped together from others leaving out or left out, and such a differentia must have rational nexus to the object sought to be achieved by the statute or legislation in question. The classification may be founded on different bases, such as geographical or according to the objects or occupation or the like. What is necessary is that there must be a nexus between the basis of classification and the object of the act under consideration. A legal and valid classification may be based on an educational qualifications. A law based on a permissible classification fulfills the guarantee of equal protection of the laws and is valid. On the other hand, if it is based on an impermissible classification, it violates that guarantee and is void. Reiterating the test of reasonable classification, the Supreme Court in Dharamdat versus Union of India held that lying down of intelligible differentia does not, however, mean that the legislative classification should be scientifically perfect or logically complete.